July 11th, 2016. My name is Liz Strong. We are here interviewing Gabe Taussig for the Legal Lens Oral History Project with the New York Preservation Archive Project.
And the videographer is Anthony Bellov. And we're live.
Great. So just to begin with, you worked on such a wide variety of cases for the city, and I'm curious about your perspective on preservation within that broader context. So what role did landmarks play in the overall health, character, and public environment of the city?
Well, my role at the New York City Law Department was to head up a division known as the Administrative Law Division. And in that capacity, I oversaw all litigation related to the city's regulatory activities. And that, of course, included the work of the Landmarks Commission, which is, among other things, a regulatory agency, and more specifically, a land use related agency. And in that context, the Landmarks Commission played a very important part in maintaining certain aspects of the aesthetics of the history, of the city rather, as well as character of many of the city's neighborhoods, and helping preserve important aspects of the city's history. And my role was to defend those who challenged actions of the commission in court.
How were preservation cases different from other areas of land use and so forth that you worked on, and in what ways were they similar?
Preservation cases were similar in many respects, technical respects in terms of how they were litigated, but they seemed to attract much more attention from the communities involved, as well as from the city as a whole and the press as a whole. They seemed to have a certain, I don't know, je ne sais quoi, in terms of people's interests. So considering the number of cases which we were called upon to handle, and compared to other agencies, there were not that many, they seemed to engender quite a bit of interest from the public at large and, as I said, the press.
Was that ever an asset or a hindrance in any of these cases? How did that change the way you interacted with them?
I don't know that it was either. Clearly, it was one consideration that made them popular among the attorneys who were called upon to handle them. They enjoyed that aspect of it. But in terms of the actual technical aspects of litigation and having to deal with the law, I don't know that that was all that different from what we had to deal with in defending other agencies.
So over your time there, how did the way these cases were handled change over time as the case law developed? Think about major turning points in the way they were handled, the way they were thought about, the way they were viewed, or even just the way you personally thought about them.
Well, in some aspects, again, in the more general aspects of the legal issues, it didn't change all that much. But in terms of the specifics of the landmarks law, clearly we were making law as we went along because there were issues raised that concerning the law which were not considered by the courts before, and in that respect we were able to establish certain precedents that later on in future litigation became less of a concern.
Give me an example.
Well, one example could be the deference that was given to the Landmarks Commission. Now, as a general principle, the courts tend to give certain deference to administrative agencies with expertise in certain areas, but that was not that clear in the beginning of our litigation of landmarks cases. But after a while, we saw that the courts were indeed, to a great extent, giving deference to the judgment of the commissioners and the expertise they were bringing to their decisions.
What do you think advocates for preservation need to know about the legal side of things, or vice versa? What do you think people in the legal world need to know about people who bring things to the council? What do you hope they would understand about each other that maybe they don't if there's a disconnect there?
Well, I think there are two questions there. In terms of advocates or anyone really who has to defend an administrative agency, the thoroughness and quality of the record, that is, the facts that are established before the administrative agency are crucial. The law will just get you that far. The certain presumptions that you might think exist will just get you that far. A strong record is crucial to the successful defense. So anyone who is advocating a particular position before the commission needs to do their homework, and a thorough record needs to be presented to the commission. The commission has its own staff, and they know that, and they are thorough in their preparation of their records. But it is a thorough record that makes a case the most defensible.
How do you think the landmarks law is perceived by the general public?
I don't know that there is one perception. I think it varies. In fact, I think it varies among communities and, in fact, among certain boroughs, in fact. There's had, in the beginning, was a hostility to the commission's actions and attempts to preserve certain communities because property owners feared that it would affect the value of their properties, that it would have a negative impact on their properties. I think that is history. I think experience has taught us, and I think most people, that in fact landmarks commission actions and the landmarking of certain districts, if nothing, enhances values. There may be discrete individual problems for individual property owners, but as a general proposition, I think that notion has been overcome.
Do you mind if we take parts of that again? It's just outside the context of my question, it wasn't clear you were talking about the landmarks law specifically. So just, begin by saying, your thoughts on the landmarks law, and then what your thoughts were.
I think there are certain communities or certain people, not certain people, I'm going to start that again. I think there are those who fear that the commission's designation of districts and the like would have a negative impact on the value of their properties. At least in the beginning, that was a pretty popular conception, and indeed I think now a misconception. History has taught us that if anything, the designation of an area as a landmark district has enhanced values of properties, and I believe that the general public has more or less come to accept that. There have been individual instances where there have been individual problems where there may not have been the case, but for the most part, I believe now that the general understanding is that designation of districts, if anything, enhances the value of property.
Have you, living in the city, seen your own, the impacts of your own work personally in certain areas? Like, is there a place you can look at that says it wouldn't be like this if it hadn't been for this, that, or the other? What are your personal connections to this?
There are certain properties that were the subject of litigation that I was involved in. I hesitate to take personal credit for that because there were many people involved, but clearly Grand Central comes to mind, although I was not involved in the original litigation, which went to the Supreme Court. There was subsequent litigation and attempts to do certain work with a terminal that did not succeed, which I was involved with. The landmarking of the Broadway Theaters District and was another case that I was involved with, and the notion that the theaters as we now know them, as they exist and will in all likelihood continue to exist for some significant amount of time. I'm a theater goer, and when I'm in the theater, I take pride in that.
Do you have a proudest moment from?
Proudest moment. I don't know if I can pick one, really. Nothing stands out as being more significant than the rest.
You brought up the Penn Central case, so I'm wondering if you can say a little bit about that, but in doing so, just, start out by saying this is the Penn Central versus the City of New York, or this is the Grand Central Station case, and then elaborate on whatever thoughts you have.
Well, the Penn Central litigation involving the original challenge to the designation of the Grand Central Terminal, which eventually wound up in the United States Supreme Court, was a significant case not only for the City of New York, but for land use and landmark regulation throughout the whole country. It is, the benchmark in so many ways and in so many aspects of the work that we do in the land use area generally and in the landmark area specifically. And it is constantly being relied upon as we continue to defend the actions of the commission, and a strong statement by the courts that the city's efforts in this area are appropriate and proper health, safety, and safety measure. And it is vital to our continued success in the area.
What are your thoughts about, just to elaborate on that, maybe compare something specific before, something specific after, views, strategies, anything to kind of show that as a turning point?
I'm not quite sure I understand the question.
So you say it was sort of a major benchmark and is important for how landmarks and land use generally. So I'm wondering, to make that concrete, if you could think of an example of how something before that case would have been handled or something after that case. And it's very open-ended, which is probably why it's confusing, but anything that comes to mind that could illustrate the importance.
Well, I think the most significant aspect of the Penn Central litigation is the fact that the Supreme Court left no doubt that localities such as the City of New York can regulate aesthetics. Up to then, it was clear we can deal with health, safety issues in the more traditional way, but it wasn't until the Supreme Court was heard in the context of the Grand Central that any doubt that may have existed in that aspect of the city's powers was swept away, and going forward, the city was able to deal with aesthetics with little viable challenges. And more recently, that came up in a challenge to the city's regulation of outdoor billboards, where the city, in furtherance of the Federal Highway Beautification Act, established rather stringent limits on where billboards can be placed. And that was challenged, of course, by the billboard industry. And the precedent established by the Grand Central litigation with respect to our ability to regulate aesthetics was crucial to our success in that litigation.
Thank you, that was perfect. Just to get specific, you said some great detailed things in your interview with Will about Dorothy Miner, and I'd love to get some of that on video. Just tell me, open-ended at first, a little bit about who she was and what it was like working with her.
Dorothy, when I first started handling landmark litigation for the Landmarks Commission, Dorothy Miner was the agency's general counsel. She was unique in many respects. First and foremost was her commitment to the mission of the Landmarks Commission. She was knowledgeable in a way that few people were about landmarks law, but she was also knowledgeable about the technical aspects of the landmarking process, as well as aesthetic considerations that the Landmarking Commission. She was the whole package in terms of her ability to effectively represent the commission and its work. She was driven. She was driven in a positive way in making sure that the Landmarks Commission's best side was always presented to the court. She was involved in the litigation that we were called upon to defend in a level of detail that I don't know that any other agency counsel was able to do. She reviewed papers in minuscule detail to a point where some attorneys were not all that happy about it, but she did nothing but add to the quality of the work we ultimately presented to the court.
Didn't she give you a sit down at some point and ask you about your?
Well, that was a mutual sit down. Yes, at some point, as I mentioned before, I represented many city agencies in the regulatory capacities, and one of the things that I did and continue to do in my time there was approach things with a skeptical eye, just to make sure that what we presented to the court was the agency's best position. So sometimes I would push back. Dorothy sometimes saw that as being less than committed to the commission and its work, which led to literally a cup of coffee between her and myself, where I explained where I was coming from, she explained where she was coming from, and whatever tension we may have had before dissipated, and we had a great relationship from there on.
So elaborate on your position there a little bit, why it's important for you to remain neutral and think about things from these different perspectives.
Well, as a lawyer for the city, I saw my role as being somewhat slightly different than just an advocate for the agency. The city's interests were typically aligned with an agency, but if the agency was doing something inappropriate, or if the agency went about doing something in an inappropriate way, it was not in the interests of the agency or the city to have a court call them on that. So to the extent that we saw that ahead of time and can address that before it went to court, I saw it my role to look for that and try to have it resolved. That's not to say that I was there to second guess a judgment call of the agency. I never did that. But if there was a procedural defect or something of that nature that could be ameliorated and would undermine the ability of the agency to proceed, I would try to address that before we had a court address it.
So talk to me about the balance of those relationships, people who get to be focused on the advocacy and professionals such as yourself who have to handle the litigation side of it. I guess just, yeah, what is the balance there? What is the relationship there? Why is that an important interaction to have?
I think it is important for the agency to have an in-house lawyer who is a committed advocate on behalf of the people, the commissioners who work there. They're entitled to that, and they're entitled to make the most aggressive statement possible. That having been said, while we at the law department are also committed to aggressive advocacy, as I said before, we also need to try to keep a bigger picture in mind, and to the extent we see a deficiency, we will have that conversation. It's a healthy conversation. Sometimes one convinces the other, or the other convinces whatever. So that at the end of the day, hopefully we wind up with the best product.
So going kind of in the other direction, stepping outside of your professional view, what are your personal thoughts about landmarks in the city, and what they mean to you, what your interaction with them has been, anything like that?
Well, interestingly enough, when I joined the law department back in the mid-'70s, I didn't necessarily have landmarks on my radar, if you will. I was going to work for the city. I was assigned to a division where it turned out we were representing the Landmarks Commission. And it was only then that I really began to focus on the Landmarks Commission and its work at a level beyond kind of the casual observer. I was aware of the commission. I was generally aware of landmarks. I paid attention to what was going on in the city. But doing that work gave me a heightened appreciation of the work of the commission, forced me to focus a bit more on the specifics of what was going on, and gave me an enhanced appreciation of the city, of the history of the city. I was a student of history, but this gave me a slightly different perspective and a different appreciation, which I don't know that I would have had in a different context.
I can sympathize with that, since doing this work I was aware of landmarks and historic preservation, but since doing interviews like this, I walk around the city with an entirely different
Right.
view of, everything is totally different for me since doing this kind of research, just the way I look at it, the way I walk around.
Right.
I only have a couple more questions for you. You're doing great at this. Everything is contextualized, everything is explained, so we haven't had to go over many of them again. One thing I do want to get your thoughts on is just tell me about where you see the future of preservation in New York City. Where do you think it's going?
I don't know that it's going to be all that different from what it is right now. Of course, as history evolves and more buildings become eligible, we're going to see more buildings designated, more different types of buildings, if you will, more modern buildings possibly designated. So in that way, it's going to evolve, but basically follow the evolution of the history of the city. But in terms of the law and the ability of the commission to do what it does, I don't see that much of a change. Typically, these type of things respond to problems that are identified. While there are certain technical problems that have been identified in recent times, concerning how long the commission considers a property and that like, I see that more as fine-tuning rather than broad strokes changes to what the commission does or how it does it.
We'll just go over that one more time because we got a buzz, and also because you started out by saying it probably won't change, and if you could just say specifically what will be changing. And then you made another great point where you said these types of things respond to certain problems. If you could just say what those types of things are, I assume changes in the law, cases that come up are in response. So just as naturally as you can,
Right.
one more time through it. Thank you.
I don't anticipate that there's going to be a significant change in the city's approach towards landmarking. It seems to be working well, while there might be changes as to the types of buildings that are designated. That's a reflection of the fact that under the landmarks law, after 30 years, buildings become eligible, and as the history of the city evolved, more modern buildings became were built. Well, in the future, more modern buildings may be designated, but that is a natural parallel to the evolution of the city. The fact is that changes, to the extent they occur, respond to problems, and I don't know that problems have been identified with respect to the work of the commission. There have been some technical issues that have come up recently, for example, how long the commission takes to consider a particular property, but I see those as more technical problems rather than broad stroke issues that need resolution.
If you could make any changes or improvements to the law or how the commission operates, in a perfect world, what would those be?
I don't know that I see anything that requires. I think the Landmarks Commission's biggest issue is one of resources. The problem it has encountered with respect, for example, to how long it takes. There are several aspects or several forces at work there, but a significant one is the fact that they don't have enough people to do a thorough and complete job that's necessary to do an effective landmarking. So they take longer and things have to wait. But in terms of their powers as defined in the law and the like, it seems to be working.
And I guess one of the last things I want to ask you is just if you have any specific cases that you worked on in the area of preservation that you'd want to go into that were fun, that were rewarding, that were a pain, that stand out in your memory.
The cases that stand out in my memory are the ones that were novel. One involved, I think it may have been the first, if not the first, one of the first designations of a building for historic reasons rather than for aesthetic reasons. That was involved. It was a photo studio of Matthew Brady, I think it was, which was in an undistinguished building, doesn't fit the typical profile, if you will, of a landmark building, but it was important to the history of the city, indeed of the country, and raised interesting issues about the power and of the commission and the scope of the landmarks law, and clearly established the authority of the commission to designate solely for historic reasons rather than aesthetic reasons. I think the popular notion was that the Landmarks Commission was there to preserve properties for their aesthetic value, and this confirmed that it was not limited to that extent. A similar novel issue was the designation of a site, an interior site, as opposed to the exterior of a building. Again, I don't know that it was generally understood that the commission powers could also extend to the interior of a building, and one of the first, again, if not the first designation of an interior was the Four Seasons restaurant, and I believe that went to the New York State highest court, and it's confirmed the power of the commission to focus on an interior of a building, solely on the interior of a building, and designate it for historic purposes.
What do you think are the benefits and drawbacks of holding up cultural or historic reasons for designation over maybe aesthetic? Is there like a way that's going that might be problematic, or a way that's going that's definitely good? Just what are your thoughts? What do you got?
I think that to the extent the commission decides to focus on historic as opposed to aesthetic considerations, so long as it's careful in doing that, and by that I mean this city is chock full of history, especially Manhattan, and I dare say you could identify some historic connection with just about any intersection in the city, but that's not going to work. So to the extent that the commission proceeds carefully and doesn't overdo it, if you will, then I think it's great. I think it's important to preserve historic sites so long as one doesn't overdo it.
Perfect, thank you. Is there anything else that you would like to be on the record? That is all the questions that I've prepared.
I'm
All right.
You know what you want.